Hey, it's Chad Brown. Welcome to another episode of the Disability Expert podcast, where we talk about all things Social Security disability and sometimes LTD and sometimes other stuff.
Whatever else comes up.
Right. That's the voice of my compatriot here, Aaron Dalton, who is once again joining us as we go through and talk about another really important issue. Get calls, hundreds every month, leads, people that need help. A lot of them are calling us to help file their initial application. A lot of them are calling us, though, because they started this process on their own and they got denied. And they are flabbergasted.
Shocked.
Yeah, I have no idea how I got denied. Because everyone who calls us has a friend down the street who's not disabled as them.
Yep, much better off.
Who got approved without an attorney, didn't take any time at all, and they got denied. And the question they want to know is why.
Yes, the big question.
The big question is, why was my disability case denied? We get two questions. Why was my disability case denied? And do you think I have a good case?
Yes.
Right. Why did it get denied? And do you think we can win? And the answer to the first question is, I really don't know till we talk a little bit.
Right.
And the second question is, it depends.
Yep.
Right. So today we're going to dive into that first question, though. Why are Social Security cases denied? So let's look, though, at the sort of the different steps of the sequential evaluation process. And we're not going to talk about each of them in detail, but just sort of go through the process and talk about why people get denied. And so start with step one. Step one is substantial gainful activity. It's an earnings question. So what are some common reasons people get what would be called a step one denial?
Yes. So step one denial is a work-based denial. So this one comes because the client is working over SGA. Now, we've talked in other episodes, there are certain arguments that we can make to try to get around that, but sometimes the judges just don't buy those arguments, and we get a step one denial.
Right. So the step one of the main reasons you can get denied is you just simply make too much money.
Yep.
In the self-employment context, and I know we've done some episodes on gig economy, and we've done some, and in the context of that, we talk about self-employment. I think that's a real confusing at times issue for people, and one that candidly you just need to get help with. The rules for self-employment, we're not going to talk about those today, but the rules for self-employment sets you up to be denied at step one because you believe that the amount of income you report, for example, on your tax return is what the Social Security Administration is going to consider. And it's just not. It's just not the way the rules work. So in the context of step one, there's also other sort of technical denials. You have, and I guess this would be pre-step one, actually. So you have date last insured issues.
Yes.
So without diving deep into the weeds of what date last insured is, talk a little about what date last insured is and why that could be the basis for a denial.
So my very entry-level explanation of date last insured that I give to clients I think it's a pretty good way of explaining it. We'll see at the end of the episode. The way I explain it, it's like car insurance. I pay my car insurance 6 months at a time. If I have an accident during that 6 months, I'm covered. If I don't renew my policy and I don't keep paying and I have an accident month 7, I have no coverage. Social Security disability works very similarly. Every paycheck, there's a little bit of money taken out, and that pays into your coverage for the system. But once you've been out of work for a set amount of time, if your disability starts after that coverage lapses, you're not going to get anything. For most of our clients, it's about 5 years after leaving work, assuming a lot of other factors we won't get into.
Yeah, sure. So assuming you worked 5 consecutive years at any sort of full-time job up until the point you became disabled, your date last insured is typically going to run about 5 years after that. So it's a little different than in car insurance. When you stop paying your premium, you lose coverage, but there's a system that establishes coverage. And that system is going to, at some point, say you're no longer covered for disability benefits. And this is we typically are going to screen and work through these issues almost before we take a case. Like we're gonna work through DLI issues. But if you don't know that, and you go into the system and you file an application and you get denied, and they say you don't have, you have found disabled after your date last insured, we get a lot of calls like, well, I don't have medical insurance, right? There's a lot of confusion, but the point is, once you leave competitive employment, there will be a stop date at some point. If in some situations it might actually be behind you, but typically there's a stop date in the future where you have to show you're disabled before that date. And so DLI issues produce a lot of technical denials. I don't want to go deep into this, but for supplemental security income, or SSI, which is, for lack of a better phrase, the welfare form of disability, there are technical denials for resources and resources and assets.
Yes. So the good thing about SSI is there's no date last insured issues.
Right.
The not so good thing is there's a lot of ways to lose coverage because of assets.
Right. And so typically, though, what's frustrating for people, though, with SSI-based claims is a lot of times you'll get denied initially, and so you'll get what we would in-house would call a technical denial. You just don't have excess resources that mean you're not eligible for the program because it is an entitlement-based welfare program. But unfortunately, if you make it through and you don't get technically denied, and your situation changes so that you wouldn't be eligible technically through the process, you can go all the way through and get a hearing, actually get a favorable decision, and then learn that you're not actually eligible for any benefits because technically you weren't eligible for the program.
Right.
Yeah, so that's frustrating. That happens. It's frustrating for us too,
Yes,
but it's really frustrating for the client. So you sort of have this sort of broad, you have technical issues and step one denials, and step one is not technically a technical denial, but it's very preliminary. When you actually get into the sequential evaluation process itself, at step two, you do see step two denials where people don't have a medically determinable severe impairment. So talk a little bit about how that comes up and what you can do to sort of avoid those type of denials.
Sure. So a step two denial can come up. There's a couple of ways it could play out. It could be that you have a diagnosis and you're just not getting treatment for it. And so essentially the judge says, I don't have the evidence to say that this is a severe impairment that's causing limitations for you. Sometimes we see where the client is actually getting treatment, but the judge is saying something like, well, the treatment seems to be working, so as long as they keep taking their medication, I just don't think that they have any limitations.
And you could have durational issues
And
as well.
durational issues as well.
Yeah, so if the impairment doesn't last for, or expected to last for 12 months. Right. And so you see people who have, God, what was it? We were screening a case not long ago where someone, I think, had an eye surgery, or maybe it was eye. I think it was eye. And the expected recovery time was going to be like 6 or 7 months or something. Right. And so we got into this question of, well, are you actually going to be out 12 months? Because you're going to be out 12 months, you get a closed period. Right. If you're not out 12 months, but that's really an impairment-based denial because the impairment is not technically severe at that point because it doesn't last for 12 months.
Right. Pregnancy complications could be another one if it lasts 9 months and then after delivery everything resolves, sure, it's going to be a step two denial.
Yeah. The other thing I think that is frustrating for people is there does have to be some type of objective medical evidence to support that you have a medically determinable severe impairment. It's a medically determined impairment that is severe, right? So if you don't have any medical treatment at all, or the medical treatment you have is not related to the impairment, then technically, I mean, you can be denied. I think at the hearing level, we see very few sort of step two denials, but they do happen. So the way to combat that is you need medical evidence to support that you have the impairment. Yes. Which leads to the other issue of, for example, in North Carolina where they have expanded Medicaid, someone might come to us who doesn't really have what I would say sufficient medical treatment to support their impairment initially. Unfortunately, we know they're going to be around for a while, right? It's going to be a while for the hearing, and if they qualify for expanded Medicaid, they're going to be able to go and get treatment, and so that's not near as big a concern to me as, say, someone who comes to us in South Carolina where they don't have expanded Medicaid, and we're looking at it going, like, I believe you. I don't think you stopped work because you made this up. Right. Could be, but it's very rare. But I don't see the pathway for you getting the objective medical evidence we're going to need to support the impairment. Right. Yeah. So I think just understanding as you go through the sequential evaluation process, you do have to prove you have medically determinable severe impairments. And if you can't, you're going to get denied. Yeah. So as you go through the sequential evaluation process, you get to step 3, which are the listings. The listings, I like to tell people, think of high school biology. And there's different body systems, cardiovascular, pulmonary, orthopedic, musculoskeletal. Different impairments affect different parts of the body. And if the impairments are severe enough, then you can sort of check the listing boxes, you can win. I don't know that it's fair to say people get denied because they don't meet a listing. Because if you don't meet the listing, you just go to step 4 of the process. But I have had judges. It's interesting. There used to be a judge in Charlotte. He's retired now. But he had this sort of convoluted understanding that, well, if the impairment wasn't severe enough to meet the listing, we shouldn't really be talking about it, which I thought was wrong.
Yes, I would agree with that.
I don't believe he was legally correct, but you do sort of get pushback from some judges because they look at it and they give a lot of weight to the listings, and say, well, the administration and the regulations, that they've determined that certain levels of impairment come from certain disabling conditions. And if we look at the listing, we see those. And if we don't see them, then they're probably not disabling. So while it's not technically a reason people get denied, understand it is sort of a gauge of severity. So I know in a lot of hearings, the reason I got in this argument with this judge once was I was arguing that they almost met the listing, and they were very close, which was really good reason for them to have an RFC that would have found them to be disabled at step 5 of the process. And that's where we got in this back and forth about, well, you shouldn't really be talking about the listings, but it's a gauge of severity. And so you get into these sort of conversations sometimes. People can be denied because they can return step 4 to their past relevant work, right? So talk a little bit about that. How does that sort of play out in a hearing where people, they have step 4 denial, right? So what's going on when that sort of part of the process?
At a step 4 denial, that means the judge has assessed a residual functional capacity. So the judge has made a decision about what the judge thinks our client can still do despite all the medical impairments. And if it is a step 4 denial, that means the judge thinks that our client can either go back to past relevant work as the client actually did it or as it's generally done in the national economy. And so past relevant work, we're looking at 5 years, 5 years back. And there's also some interesting arguments we can make about composite jobs. I don't think we'll get into those today. We just don't have the time. But there are arguments we can make about whether the job was so unique that it shouldn't be the basis for a step 4 denial.
Yeah, I think though when people, you'll see DDS level step 4 denials. Yes. I don't know that they're the majority of them, but they're pretty, you'll see a good number of them where at the initial and reconsideration stage, they make a determination, they go back to they can return to their past relevant work. And if you can return to your past relevant work, you're not disabled. It's your burden as the claimant to prove you can't return to your past relevant work. The burden is on you at that point. And of course, at DDS, you have very little ability to argue with them, right? I mean, other than submit evidence or maybe a brief, but by and large, it's just the evidence itself. I think it's important, though, that people understand you're going to have to do a work history report at the initial application, and it's very important that you get that correct.
Absolutely.
Very often, you'll have, you'll say we're preparing for hearing. Just did an episode on what happens in hearing preparation, so check that out. And we'll look through it and, we'll see that step 4 denial at the DDS level. And for me, that's usually a red flag. We need to go check the work history. I mean, we check the work history report anyway, but now we know because there's probably something wrong in it. And you sort of dig in and realize, well, the client completely, especially if they did it on their own, they completely misrepresented what they actually did in their job. They either overstated what they did because they just didn't know, so they guessed high. So like, how much do you have to lift? And they put 50 pounds and we've represented 100 people in the last 3 years for that job or whatever.
And none of them said it.
Yeah, none of them lived because it doesn't happen, right? And they're like, well, one time I had to do that. So I thought that's what I was supposed to, this one-off sort of, I don't know, somebody fell in the parking lot and they picked them up or whatever,
Or
right?
they'll say something like, well, doesn't a case of water weigh 50 pounds? No.
Yeah, they just don't know. And I think the starting point for avoiding a step 4 denial is getting your job classified correctly. And it's classified by and large based on what you tell them that you did. And so it's important, especially in the initial application, and even because you can correct it. I mean, man,
They resend the forms all the time.
yeah, but and judges get mad. They're like, well, they filled this form out and this is what they said, and now you're involved and you've changed all the requirements, and you get in these odd conversations like, well, judge, did you want me to leave it incorrect?
Just trying to be accurate, Your
Just
Honor.
trying to be accurate, Your Honor, right? But and most of them don't care, but some of them get snippy. That's the nature of judges. But I think it's important that you get it accurate because that's the first defense to not getting a step 4 denial. Because if your job is fully accurate, it's the only way it can be fairly assessed. And then furthermore, getting your medical conditions documented properly and the things you need to do to actually show the functional limitations and that are going to preclude that work. So most cases, though, at the hearing level, are going to deny it at step 5. So step 5 denials, by and large, what's your opinion? What are sort of the 2 or 3 things maybe that people need to understand are the main reasons cases get denied?
So a lot of conversations I have with clients go something like this of, well, I don't know what that job that they said I could do is, or, I live up in the mountains. We don't have that job here. So the judge is looking sort of big picture nationally. Is this a job out there somewhere in the U.S.? It's not at all tied to what your pre-disability income was. So sometimes, our clients who are high earners say, well, why are they saying I can go do a minimum wage job?
Right.
But unfortunately, that's the nature of what we're dealing with.
Yeah, and when you look at like the denial from the VE testimony standpoint, I think that's right. They get denied because there's a lot of jobs in the national economy, and there's a lot of things that you could potentially do based on certain RFCs. But more practically, what are sort of the evidentiary issues that come up that you think lead to people getting denied? Medical support, treatment, inconsistencies, credibility. Just talk through some of those things a little bit.
Sure. A lot of times we see the judges pointing to a lack of treatment or maybe some initial treatment, but no follow-ups, not following the doctor's orders. That starts bleeding into credibility type issues. The judge comparing what you said at the hearing to what you said in the function report to what you told your doctors and picking at the inconsistencies there. Sometimes age comes into it.
It's difficult to get approved if you're under 50 because the grid rules don't work in your favor. We finally did episodes on the grid rules. Go check those out if you don't understand what the grid rules are at step 5. But I think age is a big factor. I mean, one of the main reasons people get denied is they're just not old enough to have the rules work in their favor.
Right.
I think another thing that people need to understand is in the context of support letters or, expert, whether it's your orthopedic surgeon or your family doctor writing a support letter, the court assesses those in terms of supportability and consistency. But I think there's a real application of that to your case as a whole. If you say that you have certain medical conditions, the medical record needs to be supportive of that. If you're claiming an extreme orthopedic issue, you probably need to have an MRI in the record. And if you don't, it raises real questions about whether the level of impairment you have is supported by the record. Other side of that is consistency. You need to have consistency among providers. You need to have consistency among things you tell different people. So not only does your family doctor and your specialist need to be sort of singing the same tune, you need to be singing the same tune when you're talking to the different people that you engage in the process. So if you go to the ER and you tell the triage nurse, well, I was out weed eating and, I fell off the retaining wall and I broke my leg and my employer brought me here, and you're telling everybody else that you're not working and you can't afford your medications, then you have a real consistency problem across the board. And I think at the end of the day, cases where the rules aren't as favorable to you are lost largely because there's just not enough medical support to reach the level of severity to get you to the RFC you need. Or there's just sort of radical inconsistencies in the record where the judge just doesn't find, maybe not you personally credible, but they don't find the record as credibly supporting what you're testifying about what's wrong with you.
Right.
Yeah. So let's say briefly, you are denied at the hearing. I think most people at a minimum should have their case reviewed by people. I mean, you're a federal court, you're a federal court lawyer, you do a lot of federal court. Not promoting our practice. I'm just saying, as a rule, I think if you do lose your case at the hearing level, you should get that reviewed because there's a lot of reasons that cases get denied that maybe aren't correct.
Absolutely. As we talked about, only about 50% of the cases get approved in front of judges, and that's the highest level of approval in the whole process.
Right.
And I just don't personally believe that only 50% of our clients are disabled.
Yeah, and then you get into sort of arbitrary factors that you can't control. You draw judge denies them all.
Right.
And unfortunately, that was not in your favor, right? But the fact that they have a 20% approval rating doesn't mean you're not disabled. If you draw judge approves them all and you get denied, well, then maybe you're not denied. But I think it's important to get it reviewed because when people are wrongfully denied, and let's just use that phrase, 'cause I think it's accurate, you need to pursue on into the process. But if you weren't wrongfully denied, that is, let's just say the decision is pretty accurate, then there's a difference of opinion about whether you're disabled or not. You need to understand the timelines for appeals, but also what the decision is telling you about what your next steps need to be.
Right.
The power company still wants to be paid, right? You still have medical conditions. That's why you're there. And so I think it's important to get an accurate assessment when you lose a hearing so that you can make the best decisions moving forward for how you're going to come out of that. Because at the end of the day, your basic needs, housing, food, power, medical treatment, those things don't go away. And trying to figure out how you move forward from that loss is an important step. Sometimes it means you got to persevere and try to fight on. And sometimes it means maybe you need to go to VR, maybe you need to find some other options. So that's it. That's all we got. There's a ton of reasons people get denied. We couldn't even reasonably try to include them all. But I think one of the things people need to understand, though, is when you're looking at a denial and you're saying, why did I get denied? Understand that it may be an arbitrariness in the process. It may be an arbitrariness with the judge. It may be because you don't meet the sort of the categories that get paid initially. That doesn't necessarily mean you don't have a good case at hearing. Getting denied doesn't necessarily mean you should quit.
Right.
It just means you need to further evaluate what's going on in your case to see, should you pursue it or maybe you should take a different course. So that's it. That's all we got. That's all the time for today. Thanks for watching another episode of Disability Podcast. Subscribe. Till next time, take care.